Welcome to another edition of Miller Johnson Education Law's 5-Minute Message. My name is Kevin Battle. I'm a member of the Immigration Law Practice Group here at Miller Johnson. And today I'm here to talk to you about the different options available to help you recruit and retain international talent. The first option for recruiting and retaining international talent is going to be your F1 visa. The F1 visa is a student visa which allows a student to pursue their studies in the United States. Along with that F1 visa is occupational practical training, or what we call OPT. OPT is a temporary employment authorization that is directly related to this foreign student's area of study. Eligible students for OPT can apply to receive 12 months of employment authorization either prior to the completion of their studies, what we call pre-completion OPT, or post-completion of their academic studies, which is post-completion OPT. One of the issues with OPT is that it's only good for 12 months. So it's going to require a foreign national to change their status to another type of visa. The most common option for OPT students to change their status is going to be the H1B visa. The H1B visa is used for specialty occupations. Specialty occupations are professional positions that require the individual to hold a bachelor's degree or the equivalent in a specific specialty, and the position itself to require a bachelor's degree or equivalent in a specific specialty. The H-1B requires an employer to pay the prevailing wage. The prevailing wage is the higher of the rate paid to similar employees providing similar duties with the employer or similar employees within the geographic area. The H-1B visa is granted for an initial 3-year period of stay. And it also has the option to be renewed for an additional 3 years for a total of 6 years. For H1B Cap subject employers, there are 65,000 H1Bs available each fiscal year. An additional 20,000 H1B visas are available for those who have a master's degree or higher from a U.S. institution. Each year in March, the USCIS hosts a random lottery selection where all the applicants are put into a pool, and the USCIS randomly draws 65,000 with a bachelor's degree and an additional 20,000 applicants who have a master's degree or higher. If selected in the H-1B lottery, the employer will have 90 days to file an H-1B petition with the USCIS. For H-1B employers that are exempt from the cap, they are permitted to file an H-1B visa whenever they would like. There's an unlimited amount of H-1B visas that are available to those employers. The most common cap exemption that we see with our education-related clients is going to be that last category, which is the affiliated or related to an institution of higher education. In order to qualify for this exemption, the nonprofit must have a formal written affiliation agreement with an institution of higher education for the purpose of research and education. The next visa option is U.S. permanent residence, or commonly referred to a green card. The green card process requires employers to conduct local recruitment to demonstrate to the satisfaction of the Department of Labor that no minimally qualified U.S. workers or green card holders are available for the position. After an immigrant visa petition has been approved, as long as a visa is available to a foreign national under the U.S. visa quota system, the individual has the option to adjust status if they're currently in the United States or to interview at a U.S. consulate abroad to secure their green card. Thank you for joining us with another 5-minute message. If you have any questions about any of the immigration options discussed or other immigration options, please feel free to reach out to any member of the Miller Johnson Immigration Practice Group.